right, perfect. Welcome, everybody. I know that there's a couple of people that are going to be trickling in as we begin our third session for the coordinated community response with the DA prosecuting attorneys today. We are so excited that you all are joining us this afternoon for this session. As mentioned earlier with our prior coordinated community response, which is also CCR, you will also get a certificate at the end of this training. We are also sharing this live on Facebook. So for those of you joining us on Facebook, please place your comments and questions in the chat. I will keep an eye on that. We really want to make these trainings as interactive as possible. And if you think that this is a beneficial training to share, please share with your networks. And please feel free to also provide the registration link so they can join the rest of our series until December. And so we look forward to seeing you all with that. For those of you that are on our meeting training today on Zoom, you are more than welcome to also place your questions and comments in the chat, which we will keep an eye on. This is a meeting-based training, and so keep in mind with the mute and unmute button, if you have a question and would like to verbally ask it, you can use the reactions or raise your hand, and I will keep an eye on that as well as David Garvin. And we also want to say thank you to David for creating this series of trainings. And so with that being said, I'm going to hand it over to David.
Thank you, Terry. From Mission Control, we appreciate all of your work to make this happen. Good afternoon, everyone, and welcome to number 3, as you heard Terry say. We're delighted to be joined today by Rhonda Martinson and Ron Olson. I have known Rhonda Martinson for many decades. And have worked with her in a lot of different capacities. And I have known Ron for just under 24 hours.
Well, that's a risky choice, right?
Sure
is. And we're delighted that both of you are joining us. And I'm going to turn it over to Pam Wiseman to give a formal welcome to everyone.
Thank you. It probably won't be very formal. It will be more like welcome, everyone. And thank you so much for being here. As David and Terry said, we've had a great response to this series. And so we're really excited about it and glad that so many of you could be here. I just want to note that Ron Olson is a member of the Domestic Violence Coalition's Legislative Committee. And so that committee looks at policy initiatives and various pieces of legislation. What legislation do we need? What do we not need? What are some implementation issues? And he's been a very active and helpful member of that group. He also works at one of our member programs in Taos. So he has a long history with domestic violence. And I would say a lot about Rhonda. But just like David said, he didn't know Ron very long. I haven't known Rhonda very long either. It's less than 24 hours. It's been about 5 minutes, I think, since we've met. But I have heard really great things about you. So I think with that, just welcome everyone and thank you for being here. And if you have any questions about the coalition or what we do, you can put it in the chat, and I think Terry will be happy to answer those questions. So that's it for me. Thank you.
Thank you, Pam. And with that, Rhonda and Ron, we're going to turn it over to you. You can go ahead and share your screen when you're ready.
Ron, would you like to go first while I pull up my PowerPoint?
Sure, I'll just introduce myself. As you've just heard, I'm Ron Olson. I have been working at Community Against Violence here in Taos, New Mexico. This is my second stint. I was there for about 2 years, from around 2013 to 15, when I took a break and went back to what I used to do up in Colorado, which is to be a prosecutor. I worked in the 8th Judicial District Attorney's Office here from 2015 until just about 2019 or 20, when I went back over to doing what I love, which is working with survivors of domestic and sexual violence through Community Against Violence up here in Taos. I have 2 daughters. One is attending college up in Colorado at Regis University, and my other daughter is attending as a senior in high school up here at Taos. And My wife is actually the Director of Social Services over at Taos Pueblo here in New Mexico and has worked at CYFD for a number of years prior to doing that. So I look forward to being here. I hope I have some valuable information to share. I understand today I'm speaking primarily from the perspective of a prosecutor, and I hope I'm able to provide some insight into that. And those of you who may be doing that job, hopefully will be able to relate with some of what I'm talking about. So that's about it for me.
Thanks. Again, my name is Rhonda Martinson. A little bit about me is that I began my experience or knowledge or education on domestic violence and actually having the experience of being a domestic violence victim. Got married right out of high school to someone that turned out to be a very violent person. So I myself have experience with both a good and a not so good police response with legal services, court appearances, other resources. And my experience, I think, will be able to illustrate a few points as we go, because it came back to haunt me probably 20 years after the fact in kind of an interesting prosecutorial way. So I'll probably end my presentation with a few comments about that. But onward from there, I worked my way through college as a 911 call taker and a jail officer. From college, I went to law school, and 3 days after graduating from law school, became a domestic violence prosecutor. All of this criminal justice experience took place in sort of small town / rural Wisconsin. And from there, got lucky enough, I didn't realize it at the time, but lucky enough to be in one of, it was 7 pilot communities in Wisconsin that were attempting and exploring the idea of a coordinated community response. And so I got to go to trainings by Ellen Pence and Casey Gwynn. Again, I didn't realize how cutting edge that was and how it would become in the future. So fatefully enough, about the time that the Violence Against Women Act was being passed and creating all these resource centers and trainings, somebody poked me in the ribs and said, hey, there's an ad in the St. Paul and Minneapolis newspapers for a staff attorney for this new organization they're starting up there called the Battered Women's Justice Project. They're looking for someone that's a woman or has worked with women in domestic violence, who is a prosecutor and has done training. And at that time, it was hard to find all of those in one person. So I checked it out. I never heard of anything like this. And there I landed into the resource and training and consulting world. And there I stayed for about 17 years. And in those days, you did not just do training. You were often asked by the Office on Violence Against Women in the United States Department of Justice to do a lot of unique things like evaluate programs, do site visits, participate in research, read and stay up on research. And so over the years, I've been involved in probably 75 what I would call community assessment type projects, doing things like evaluating prosecutorial responses, law enforcement responses. And I'll allude to many of those kinds of experiences and what they produce throughout the presentation. Last but not least, a couple of things. After working at BWJP for 17 years, I got an opportunity to manage a really interesting project for Equitas, which is another resource center focused particularly on prosecutors who are working on violence against women cases. And I got to manage a 3-year project studying witness intimidation in domestic violence cases in 3 different cities: Duluth, Minnesota, San Diego, California, and Knoxville, Tennessee. And that also has provided me a lot of thinking, you might say, as it relates to how not only domestic violence generally, but how people are often prevented access to justice by the actions of abusers and sometimes inadvertently the system itself. And so again, we'll be alluding to a lot, because those are perfect topics for coordinated community response. And then the last 7 or 8 years, I've been consulting on my own. As I got older, I just figured, I'd like to try working for myself. So I do pretty much the same stuff that I did at Battered Women's Justice Project and Equitas, but I work for myself as an independent consultant. And behind me, before I forget, I just realized this last night. This is actually a print of a oil painting done by David Knowlton, who I think is a somewhat well-known artist in Santa Fe, New Mexico. He studies and paints old rail stations. And so in the Southwest, you would have a lot of that sort of older adobe kind of architecture, which is very unique. You don't see that in Wisconsin, obviously. And he actually was my neighbor for a while in Wisconsin and gave this to me as a gift when I began work at the Battered Women's Justice Project. So it seems very fortuitous for me to share that with you today. Okay. Ron and I are going to run this show in kind of a tennis match approach because I have this kind of national perspective and national work that I'm doing now. And Ron, of course, is local to you and I think is especially valuable experience, not only as a prosecutor in your state, but as someone that has become involved in legislative prioritizing. And so what we're going to do is kind of do this nice back and forth of talking about like CCR generally or some national perspectives, and then allow Ron to step in and make some points as it relates to local experiences, questions that might be unique to New Mexico related to resources or statutes, for example. And additionally, I would really welcome people to chat in questions. So Ron might make a point or be able to answer a question. Terry and David, I assume you will monitor the chat. So just break in, and we've got plenty of time to answer questions. And I would think that would be much better to do that as we go instead of waiting till the end. So jump in at any time. And there are going to be times where we do ask you questions. So again, be ready to chat in. So when David asked me to describe what it is that I might present or that we might share with you today, and given what I know to be the goal of this series that you're doing in New Mexico, I just wanted to overview this very quickly for you, that it isn't just for prosecutors. I know we have many different kinds of practitioners and professionals in our audience. This is a coordinated community response training. And so we're talking about partnerships and working together. So this workshop will be just as valuable for those kind of usual suspects in the criminal justice system that work with prosecutors, law enforcement officers, victim advocates, probation officers, judges, program facilitators for offenders, CCR leaders, whatever the case may be. You should find this valuable about developing or strengthening prosecutor interventions in domestic violence, victim safety and offender accountability issues in that work, as well as our own accountability as a system. And so we'll talk about CCR philosophy and work. I won't spend a lot of time on philosophy because I understand that you actually had the pleasure of court innovations actually defining CCR for you. But I think it gets frustrating if you don't tie that quickly to very specifically, okay, what are we going to do? What actions do we actually take in a coordinated response? And so that is the way in which Ron and I will be communicating with you today. Like, what is the work? What do we do in a good quality coordinated response? Just some tools and then how to apply them in the realm of domestic violence prosecution. Again, it's not helpful to just talk about CCR work generally. It's more helpful when we're doing specific practitioner group trainings like this to apply it at each step of the way to prosecution. So we'll do that. And then also emphasize victim safety. That is our goal, not our own efficiency. So we'll talk about how victim safety is actually enhanced by doing these things, and share some problem solving strategies at the end. So I found this little cartoon that I thought was a perfect beginning for today. This is not a CCR where you just get back like, sure, we work together, but the problem is theirs. We can just sit back and let them fix it. Nope. That's a big nope. Instead, the work of a coordinated response looks like this, where each person is knitting, like with knitting needles together, what it is that you're doing, who's doing what, making that, how shall I say it, published or written down or available to everyone. I remember one of the projects that I mentioned to you, working on it in a very small community. And I swore to them at the end of the project, I was going to buy them all t-shirts that said across the front, we do that, we just don't write it down, because that's what I get. Every time I spoke to someone or reviewed a report or asked a question or interviewed somebody, it was, well, we do that, but we just don't write it down. And so one of the things that you're going to see us emphasize today is the importance of policies and protocols, making clear to your partners what it is that you're doing, how you'll be accountable for doing things, and then also sharing information. And it's one of those little interactive slides that I really usually don't care for very much, but you can't get rid of. So other things that I think are very important in a coordinated community response that you can't really do as a lone ranger is checking in with one another to see if what your policy is, your intervention is, has unintended consequences against particular kinds of victims, for example, or particular kinds of offenders or children. And we'll talk about that later on as well. Is every door open, or are you just do you specialize in DV on Monday afternoons, for example? And does that create problems for victims? Are you all on the same page, or do you really have a different understanding what victim safety means? All of these things are the work and actual activity stuff you should be doing in a coordinated response. It's not just, again, some sort of vague pie in the sky ideal. It's stuff you should be doing. So let's get to it. And Ron, here is where I will welcome you to jump in at any time, or if you just want me to pause at the end of this list. The list is rather short, it's like 8, so your pleasure either way.
Yeah, so as you enter into your coordinated community response plan, and I won't just read off the list here, but one of the most important things that you got to think of is you all have to share a common goal, and you want to think about the best way of communicating that goal amongst yourselves. If you get into a room with law enforcement, prosecution, you may have nurses, the medical personnel in your coordinated community response team. You want to make sure that everyone is kind of on the same page and that you want to end up in the same place. And whether you define that by, keeping survivors safe, if that could be a goal, and you just want to have a clear set of philosophies listed, and you want to talk about that. A nurse may have a different perspective about what her job is in protecting this woman who's been abused, or these children who are now in front of her after a battering incident at home the prior night. And so you want to make sure, and law enforcement too, they have an objective of arresting people if they're able to locate them. And actually, a lot of law enforcement have a goal of really seeking offender accountability, and they want to have these people held accountable. And the way that they do that is by enforcing the laws that are on the books. So when you're putting your team together, you want to make sure that you're sharing a common philosophy and that you all know that you're working and striving for the same thing. On that picture that Rhonda had placed with everyone bailing out the boat, if you share that common philosophy and know where that boat is heading, you'll have a much easier time when you encounter the rough seas. When you have those ball that got dropped, if a report didn't make it from the police to a hospital, for example, or if your offender got out of custody more quickly than you expected, you want to have you want to know that you're all on the same page in what you're trying to do in those moments. As far as creating, maintaining, and updating best practices, policies, and protocols, up here in Taos, we have had a coordinated community response team in the past, but I have to say it's operated at various levels of success. And I think it kind of relates back to that common philosophy that people have, and you've got to maintain and make sure you're all on the same page. When you have your best practices, policies, and protocols, you actually want to have a book. I mean, something that you can all turn to when you encounter a problem in a response, or you're reviewing a case that maybe had some holes in it. You'll want to be able to turn and see, well, where did we screw this up? What was the hole or gap in our system that we found? And how can we fix that? And then when we encounter it next time, how will we update our policy so that we know what to do? One of the most critical parts of any coordinated community response is how your agencies share information. Up here in the 8th Judicial District, we've seen law enforcement trying to work to a common system. They talked about using a Stedman system, which it's a complete database, I guess that you would say, both handling criminal histories of offenders, as well as what's going on in the court system. And they've been working for an extended period of time with grants, trying to get the same systems that law enforcement use to be accessible by the overall criminal justice system, from judges to the prosecutor's office, even to the public defender's office. How can we all share this information and make this community as safe as it can be? And that's what we're talking about here, is how do we improve our community? And it's not just one group of individuals that can do that. It's these groups of people that are involved and come in contact with our criminal justice system. And I think we've all been part of it and seen it, where we have difficulty sometimes sharing information. There are different philosophies, again, out there amongst some elected officials, I suppose, and our district attorneys, how much information they're willing to share in their job as a prosecutor with the public. How much are they concerned about the ethical considerations of discussing and sharing information? How does that put some of the witnesses that they may have at risk when they're considering what information to share with other agencies? And what is the best way to do that in a way that serves the purpose? Like, we want to protect victims. How can we share this information without putting them at further risk than they might have been had we not put this information out there? You've got to have a way of monitoring and tracking your cases, and developing a system for first qualifying what type of case you're looking at. What are the outcomes that you're trying to achieve in those various cases? Is it simply, did you successfully refer those clients to the agencies that you're trying to provide them services with, or at least put them in touch with? Or is it more of a perspective of, well, we had a domestic violence case and now that offender got convicted and is in jail, or got convicted and is now also taking some therapy and doing some things to improve themselves and their potential out in society. So you want to have a clearly defined way of monitoring and tracking the cases, and different agencies may have different things that they're tracking in different ways, but you all have to remember you're part of a team, and how as a team now of individuals within the community can we best evaluate the work that we're doing to make sure that we can continue doing it better. Ensuring and supporting community resources for survivors. In Taos, we've had a real issue historically with having communication and really knowing what services are out there. And this pandemic has really thrown things up in the air, I suppose, even more, although, as you've all seen, the fact that we're able to have this meeting with over 100 people of us, 100 people all joined together, and that didn't happen a year or a year and a half ago to 2 years ago before the pandemic started. And we're seeing improvements in community resources and the ways that we're able to get those resources out to the public. Many of these agencies that used to kind of just be a building sitting off to the side in your community, or that's the shelter, the battered women's shelter over there. And over here we have the alcohol treatment center, but nobody was really communicating to know that perhaps this individual or a certain individual was getting batterers intervention services while at the same time going to a different agency in your community to receive alcohol assessments and treatment as needed. Maybe that person's children was ordered as a result of the incident originally. Maybe the battered partner went out and got an order of protection and The children are now receiving community services and therapy at a community organization. And wouldn't it be ideal if all of those agencies were able to communicate with one another about this family and about services that they're engaged in, and to check in periodically about how this family and this client is doing. And so you've got to make sure that you are out there speaking with the agencies that are involved in that, making sure they're aware that you're trying to gather this more coordinated community response team, and that you want it to be successful, and that you're willing to help them get the word out that they exist. You're willing to help them communicate with other leaders in town and to make their services known. Then there's part of the coordinated community response of intervening directly with abusers. Sanctions, restrictions, and Rhonda, please feel free to jump in at any moment too if you have anything to expand on what I'm saying, or if you want to come at it from a different angle. But as far as intervening directly with abusers, I think we can get directly a little bit into recognizing that we need to have our criminal justice system as an important part of our coordinated community response. If we're able to have judges sit on the team from time to time, or to share their philosophies again about punishment or sanctions for abusers, what type of philosophy they believe in. Is it punishment first and rehabilitation second? Or are they more reading some of the research out there that says that we need to get these abusers into treatment as soon as possible? And if that means adjusting the way that we handle these criminal cases in the courtroom in a different way, and perhaps getting people into treatment right away, and then letting their case be handled within the ordinary course, or perhaps on a, the track that we all see, it's going to be delayed and not as quick as what we would all like to have. And so how are we going to, as a coordinated community response team, what is our philosophy going to be, and how are we going to intervene directly with abusers? Combatterers intervention programs, are we going to sanction people when they have a violation for consuming alcohol, for example, when they're on probation? And how do we best deter violence in our community in making these interventions and trying to help to the extent that we can, whether that's by punishment or whether that's by offering services to abusers and the various types of things that we can do. Being aware of and working to undo the harm to children. And this is one that I think hits home for me, one of the hardest, and one of the biggest passions, I guess, that I have, and reasons that I love this work, is that, everyone forgets that every abuser and every person who's victimized, and I don't think that maybe people don't forget, but they fail to recognize, I think, when you've got an abuser sitting in front of you, for example, that person was once a child too. And are they sitting in front of you because of the experience that they had when they were a child? Many people have never learned any way of treating the other person that's important to them, other than the way that they learned it from their parents. And some people did not have the same experience as us. And we need to be recognizing that these are families that we're dealing with. And how can we best undo the harm that's already been done to these children? Oftentimes as we're all aware, when people finally make their way into the justice system, usually it's not intentionally. Usually it's because something got so out of control that the rest of society had to step in some way by enforcing a law, or because a neighbor heard screaming next door, or the kids came out running in their pajamas because mommy and daddy were fighting again. None of that was planned. But now they're in contact with the system, and odds are some harm has already happened to these children in that family. And how, as a team, can we best put people in contact with the resources, with the child advocacy centers in town? How do we make sure that there's a safe room interview that can be conducted? Do we have sane nurses available to us in our community? And how can we reach out to the medical providers and see the best way that we could get those services into our community? Are there traveling nurses or people that are willing to come into our community and help us with some of the best practices that are out there in dealing with children? Because when we can undo some of this harm to the children, that's how we're stopping violence for the long term. Maybe one day these people will behave differently because they'll be the adults sitting in front of us in this system. And then importantly, we've got to periodically evaluate how we've been responding. And this brings us back, as you can see, I mean, we will see, have we met our philosophy? Is our system this work that we've been doing, is it in line with the philosophy? Have we achieved that philosophy? And how have we got our batterers intervention program? Just, are we communicating as a coordinated community response team? Where are our weaknesses? And then trying to make those improvements and make adjustments to the written documentation that you have and the policies and procedures that you have put in place so that you can improve the following year.
That was great, Ron. Thank you very much. Just kind of nicely stepping through that list so we get a general idea. And so now we're going to move forward. As I said, we're going to tie these 8 different activities, again, things you should actually be doing, to the work of a prosecutor. So if you are applying this idea of building a common philosophy, what does that mean? What do you do? And while I'm saying this, you can see a little picture there. You can see kind of this image of, 2 groups of people kind of tugging back and forth. This may not be an easy conversation to have. I just want to, it's not like there'll be like 1 hour over coffee and everyone will agree on what victim safety means. I can think of a lot of stories from Duluth, Minnesota, for example, where people really struggled and got angry and upset over the aspect of victim safety that would have to do with situations where the victim was alleged to have used violence herself, where it may be that both parties were going to be looked at for charges, or where there perhaps had not been a very good evaluation of self-defense or a predominant aggressor. And so what safety meant in that situation raised a lot of hackles until they shushed that out. But I digress a little bit. So what I'd like you to do as I talk about each of these things a bit more in depth as they tie specifically to domestic violence prosecution is you in the audience, perhaps from your own experience or your own questions, chat in a potential gap that you might see or struggle with these in your own jurisdiction. So what it means to build a philosophy is thinking clearly about situations that perhaps have become somewhat institutionalized by victim blaming. No, people aren't probably saying, I blame you, ma'am, but they may be doing things that are more subtle, unspoken, or even inadvertent by the way that you process a case, for example, that appear to blame victims and thus make victims less likely to call you for help again. How does it you understand domestic violence, the relationship between the offender and the victim? These are all things that you probably will have to discuss and find out that you have differences, the way that you were brought up, the way that you were educated, criteria that you use for making decisions in your own work, whether it be child protection, judging cases. These things kind of present different ways for us to have critical thinking and analysis skills. And that doesn't mean someone's wrong. It just means it's going to take some peeling back of layers to figure out what it is that each of us actually means by these things. And so a quick example is, from my own experience, is when I began prosecuting, states were just starting to look at creating anti-stalking statutes. In other words, criminalizing that behavior, which was a big deal at the time, because if you think about it, it's really one of the only, or if not the only, one of the few instances where you're criminalizing a pattern of conduct as opposed to an incident. And so if somebody was doing what we would call stalking behavior, when I started prosecuting in Wisconsin, you had to charge a lot of separate crimes in order to hold someone accountable for, even if you understood that it was stalking behavior. However, not everyone understood that because we hadn't done a lot of legislative work in that area. So I can think of a situation I'm prosecuting a stalking case that basically I had to charge the person with a whole bunch of disorderly conducts because there wasn't a stalking charge, but yet I understood I was dealing with a pattern of behavior. And so in brainstorming that with other prosecutors in my office, I got pushback from one who I had thought was a really good domestic violence prosecutor. And she said, well, this isn't stalking, it's unrequited love. He's just expressing his love for her, and she isn't returning those feelings. Basically kind of thinking that if you just gave him time to get over it, or spoke to him to give him some closure, or maybe helped him get counseling, that would be all that's necessary, that I shouldn't be viewing the charging and prosecution theory this way. Similarly, the judge ended up handling this case, was clearly angry with me at bringing these charges, and because the case went to trial and the jury did convict him on all these disorderly conduct charges, because they, I think, could see what the story was. He basically said, I don't think that the criminal justice system is an appropriate monitor of this person's behavior, so I'm just going to order probation with no conditions and suggest that the young man get counseling. So it was like, wow, here I am working in a community that's supposed to be a pilot in Wisconsin for a coordinated community response. And here's really clear examples of two people that did not have the same definition or the same philosophy of victim safety that we all thought we did in domestic violence cases. Anybody chat in another potential gap or difficulty in this area of building a philosophy, a common philosophy that includes the presence of a prosecutor? No.
Rhonda, I just want to jump in and say that when you're talking about the philosophy, my experience with this, and actually you might have been part of the technical assistance for Washtenaw under the Jody grant. I don't remember who all the TA was, but there was a lot.
Oh yes, yeah, I was there. Yeah.
But to have that philosophy, you all had us actually talking about it for 2 days. So it's not like, hey, what's your philosophy? Here's my philosophy. It was a process to knit this together, to work on the wordsmithing, to talk about it. And as Judge Hines clearly says, we cussed and discussed it for 2 days until we came to a conclusion about a philosophy.
Yeah. And one of the reasons why I'm going on a little bit about this, perhaps more at length, is I do a lot of law enforcement training, and I have done a lot of law enforcement training. And I have some empathy there, because they sort of get blamed for everything, that, well, we're not doing this because the police didn't document it well enough, or we're not doing this because the police screwed this up, or the police should have told her that she could have gotten this resource. And what I hear from law enforcement officers who actually will stay after and talk to me and get really, frustrated to the point of tears sometimes, yeah, but where do we get our messages from at trainings, or when cases are dismissed, or when cases are declined, but from prosecutors, judges, and defense attorneys? There has to be a really clear understanding between those partners, as opposed to just saying, well, I'm going to sit back in my chair and wait for the good police report to come in. No, if there isn't a common understanding of what is, quote, good, there isn't going to be that level of good work and CCR work. So moving on to policies and protocols. And again, David, as somebody chats something in, just give me a sign. Again, I'm looking to see if you all have an idea or an experience with a potential gap in this area. But if you are working together to make policy and protocol, again, we do that, but we just don't write it down, doesn't cut it. Policies and protocols are a way that all of our partners can be aware of what each of us is expected to do. So it's a way for us to better advise victims what to expect. It's a way to better train new staff as to what they can expect and what they should be doing. It's a way to hold us accountable. And so policies or protocols should guide people, and it's a way for us to provide training. I don't know how it is that you can train someone well, a new staff person, for example, or to update current staff, if you don't have policies and protocols from which to train and from which that person can refer occasionally if he's forgotten something or is trying to figure out what to do. So back to my more sub points here, you should be able to tell, you should be able to govern what a person is, how a person is supposed to respond to a specific case. So I just gave the example of stalking a while back. Well, what is it that you want that person to do in a stalking case? Is there more tailored safety planning necessary because of the pattern of behavior? Is there additional documentation given the newness of the statute or the difference of the statute, and again, criminalizing a pattern of behavior as opposed to one incident? I remember being invited, again, there's a lot of back in the day stories at the beginning of all this violence against women work, where the Stalking Resource Center was first being created. So people like myself got invited to meetings as this new resource center was being created as to, well, what should we be doing? How should we prioritize? Because it was felt that there was a lot of attention at that time given to the celebrity stalking cases, but not very much attention or knowledge or training as it related to the more common kind of stalking, which would be where you had a relationship with that person previously. So we had a meeting and the center was created and had more than a lot of meetings. And 10 years later, we had an anniversary meeting of all these people that had participated in that advisory effort about how things were going. And one of the prosecutors that was at both meetings stood up and said, you know, now all the states or most states have stalking legislation, which often didn't exist 10 years previously, but we still have almost zero prosecutions of stalking. And he said, why that is stalkers themselves have become more sophisticated as our statute has become more amenable to charging a pattern of conduct. It hasn't kept up with technology. And he said, so now what we have is stalkers realizing they can get the same, he said, to put it really bluntly, as one person said, and unfortunately it's very blunt, I don't have to kill her anymore or beat her up to get satisfaction. I can just go online, I can ruin her life, I can ruin her reputation at work, I can create a lot of harassing conduct for her by putting her on a website or on Backpage or something of that sort. I can text her from spoof numbers. You know, I can go on, but you get the idea. And he said, basically, I can just make her life miserable and nobody's going to do anything about it because nobody knows how to respond to the use of technology and social media. And we're getting better, but that's still a big issue. So again, you can't expect people to do something. We can't just sit back and blame, oh, the police did a crummy job, if we don't have policies and protocols that help the person respond to specific cases. We've done the same thing with strangulation cases, for example. Now there are statutes against that and training. So I could go on, but again, you get the idea. And a gap that I will give, an example of a gap, as people may consider chatting something in, is working with Praxis International frequently, who is another longtime National Resource Center on domestic violence, cautioning people not just to kind of rubber stamp a neat new policy that they heard at a training. You know, that's really unfortunate too. You get people all excited about doing something good. They take a policy and it's like, we're going to start doing this. And Praxis has always had a really good training on, wait, before you do that, I'll just try to shove something new in your community. Here's a checklist to figure out any possible issues that you could create by implementing a new policy. So it goes on for a page. I just kind of gave you the top here. And by the way, anything that I mentioned in this presentation is something that I can access for you. So I told David that I would commit to answering any questions after the presentation, meaning like if people wanted to email me the next day. So if I mention a form, a piece of research, some case law, that's something that I have access to and I'll be willing to send to you. So I'm not just kind of speaking vaguely, I want to assure you that I can send you anything that I'm referring to. So this checklist actually goes on to talk about, does it account for situations where it impacts a particular group of victims negatively? So for example, someone that's undocumented or has some sort of immigration status, is this going to immigrate, this particular policy of your response going to inadvertently negatively impact them? Is your connection with CPS going to inadvertently or negatively impact the way that this family is treated once they intervene in the lives of children? Is there any way that a staff person, a worker, a practitioner can get around the policy? And if you kind of figured that out, so we have many, now that everyone's into documentation, and a lot of officers are frustrated with the time that takes. But hey, if 911 doesn't code the call as a a DV call, you might not have to write a report. So have you figured out situations like that you can policy and protocol your way around? So if you're thinking carefully about gaps, one of the ways to look for them ahead of time before you fall into the trap of gaps is to actually utilize a checklist like this before you implement policy, like what gaps and pitfalls are here that we might not have thought of, and how can we fix them now instead of address them later when it's problematic to do so. Any chat-ins, David?
Not yet.
Okay.
There were some questions that I'd like to have asked in a different one of the trainings about judges. Today being focused on prosecutors, I want to give all the time to focus on prosecutors. One question though was, can people get a copy of the PowerPoint that's being shown today?
Yes.
Can you?
Yes.
Okay. So
And
everybody on the call, we'll get that out to you. Rhonda, you'll share that and we can make it a PDF and then share it with
yes.
people.
In fact, if you have anything else that you want, what I can do is just send a really nice email if somebody else asks for something that I mentioned, and then that can just be sent to everyone. So I don't mind doing that at all. I'll be happy to do that.
One thing I think I would throw in too about the need of your coordinated community response to have policies and procedures is to remember that all DAs are elected officials in the state of New Mexico, and you'll want to have a policy and procedure that hopefully your organization and your coordinated response can last beyond just your current elected DA, or if your current elected DA plans on being the elected DA for the next 20 years, that you have policies and procedures in place so that as the other attorneys that enter that office get assigned or want to be part of the domestic violence prosecution, that they themselves can be familiar with the policies and procedures of that organization so that they can take advantage of the organization by meeting and actually being involved with the organization as opposed to just showing up at the meetings, but they can be familiar with the policies and protocols in place. And if you do have a newly elected DA, your organization remains strong enough that you maintain your meetings and you keep going forward, hoping that that DA and that office remains as involved as they have been. And that, turning back to the policies and protocols and having them in place and seeing that the district attorney and the prosecution office is a required entity in your organization, they can make a smoother transition when you do have a newly elected district attorney or one retiring or those types of situations.
Yeah, that's really a good point. I'm glad you mentioned that because Praxis actually had a PhD that they were consulting with for a while, interview, I think it was 7 communities that had implemented new policies related to domestic violence after doing a project kind of like looking at this checklist. They investigated some kind of problematic aspect, maybe through activities like looking at reports together or prosecution files together. And everyone that she interviewed said it actually was kind of fun doing the investigative part, like looking for the gaps or kind of asking their group in a multidisciplinary work session these kinds of questions and kind of figuring out these things. But actually implementing the new policy was the part that really was difficult. People you can say that you're going to do something, but by not keeping at it, by not having meetings regularly in a way that sort of refreshes people, reminds people, hey, we've got this policy, it tends to go away without that continued work. And I thought that was really interesting that once people started a CCR, they actually rather enjoyed the sort of investigative part and creating new stuff. The implementation part and keeping it that way was what was often a failure or a difficulty. Here's, I think, something that's really important and perhaps one of my main points as it relates to prosecutors in a CCR. When you think about it, they're really different than other people in the criminal justice system in that they're not doing a report. In other words, a police officer or even a 911 call taker is making kind of a little memo style report in the computer aided dispatch portion of their software. A police officer is making a report, obviously, when they answer a 911 call. A follow-up investigator is making a report. A probation officer that's conducting a pre-sentence investigation of a domestic violence offender is making a report. But the prosecutor doesn't do that. They're receiving all this information, like they're the hub of these spokes of this wagon wheel that I put here, receiving all this information upon which they then have to make a decision. So they're not making the information, they're not making the documentation, they're getting it from all these other sources, prior records, maybe prior prosecutions, advocates who are assessing risk or in frequent communication with the victim, all these things in addition to law enforcement and probation, like I said, pretrial release evaluations. I used to get reports occasionally from the jail about behavior issues that would impact a prosecution. I could go on, but you get the idea. So if we're talking about the work of sharing information, the goal of sharing information is to make the domestic violence visible to the next person that has to do something about it. If it's not visible, they can't do something. A probation officer isn't able to credibly request conditions be ordered by a judge if there's not information about safety and violence in the file or in the report. A prosecutor isn't going to be able to charge, elevated charges, is not going to be able to charge a person as a repeat offender. There are many things if certain things aren't documented. A prosecutor likely isn't going to be aware of witness intimidation, which is a very common occurrence in domestic violence cases, if there's not communication with the victim advocate, who is likely going to be the first person to hear about that sort of activity. So that's why I put up this picture of not a perfect wagon wheel, but one that's got a couple broken spots there, because that's what happens when that connection to the hub of the wheel, i.e. the prosecutor, is broken. You're not getting the complete picture of information. So when it's a huge responsibility for the prosecutor who isn't doing the investigation, him or herself, has to rely on all these streams of information. And again, as I said rather bluntly before, shouldn't be relying on just sitting back in the chair and waiting for that information to come, because those people need to know, what kind of information do you need? What quality level or comprehensive level should it be at? When do you need it? From whom should it come to make sure that it's most credible? These are all important things that you have to discuss in order for it to be valuable. If prosecutors aren't communicating with all of these spokes of the wheel, that's another way that the spoke gets broken. Is, sure, I'd be glad to do that work for you, but I didn't know that it was needed.
Yeah, and you'll see that in New Mexico, as you've seen many times, there are different roles in different prosecution offices for these victims' assistants. Some of them that work within the DA's office directly have different job definitions and what they're allowed to do depending upon the elected DA that they work for. I have been aware of some district attorneys that want their victims' assistants to do nothing more than what's statutorily required. They don't want them out there, putting their office, the DA's office, at risk by making statements to others or making promises to victims that ultimately the prosecutor may or may not be able to keep. But you also have some district attorneys who have who enable their victims' assistants within their office to work more freely, more hand in hand with the victim. And it's really up to your community and your team to determine which type of prosecutor you have. What information is flowing out of that office to you, and what information have they told you that would be helpful to them to receive? I can tell you that it's a difficult thing when you're a prosecutor to have a domestic violence incident occur, let's say on a Friday, and you have your offender sitting in custody over the weekend, all the while their spouse is now trying to figure out how they're going to get the children to school on Monday morning, and finding out that he's now encouraged his best friend to show up at her house to intimidate her not to show up to the hearing. And she's dealing with a whole bunch of different issues, and the prosecution, as Rhonda has said, may not know that he's also intimidated her if you're not sharing that information. And if the prosecution isn't allowing you to get that information to them, you have to figure out a way to kind of get that DA's office on your side or working hand in hand with you. And some district attorneys will put up those barriers. They say, we don't want information. We're concerned about leaks out into the community, and they may have valid concerns. If witness intimidation is one of them, but also, are they actually putting a witness at risk by sharing some of this information with you? And so those are the concerns a prosecutor may have when they're considering what information to give out to you and what information they're willing to take from you. And you have to keep in mind that most everything a prosecutor receives, almost everything, ultimately gets handed over to the defense. And so that's why you again turn back to the policies and procedures, but you've got to be clear with your prosecutor. What information should you be sharing with them? What information will they be sharing with you?
Yeah. And again, in the spirit of just giving an example, as so this doesn't stay too up in the sky or too vague. A lot of times there are a lot of rather simple or small obstacles that it's kind of like we've always done it this way kind of thing, and you just aren't aware of it. So a new thing that I've run across, but I suspect is happening frequently everywhere, is with the advent of body cameras. I'm working on another project for someone else right now where I'm looking at 100 police reports in a large city of patrol officer response to domestic violence calls. And some of the reports are rather terse, short. But when you talk to them, what you hear often is, well, they can look at the body camera. They can look at the body camera. They can look at the body camera footage. And it's like the prosecutor says, well, oh my God, I get hundreds of cases a week. I can't queue up 45 minutes worth of body. I mean, it would be so much faster just to riffle through a report. If I've got people in jail that I need to make a report on, it may seem more thorough and efficient to the police officer who's capturing all that on body camera. But I can't look through 45 minutes of body for every single police report to make decisions about charging or, bail. So I thought, well, this is an interesting issue. What does sharing information really mean? The police think, wow, this is a treasure trove of information. We're giving you access to our police information management system so you can look at body cameras. And the prosecutor is rolling back in his chair saying, that isn't sharing information. You're giving me an impossible kind of like the discovery thing of defense attorneys burying you in paper. That's kind of the virtual version of that. Or a smaller example would be a community that I worked with a few years ago. One issue that they had kind of investigated on their own, and I thought this was really cool before I came, because they knew what I was going to do, look at files, talk to people and stuff. And they said one issue they had that they just couldn't figure out is warrants for what we would call gone on arrivals. You get a call, somebody's done a domestic violence crime, but they run off before police get there. Well, then if you can't find them right away, you've got to go get a warrant. And so they had a real good ethic about knowing that was important. If he's out running around, that's dangerous. So trying really hard to get those complaints and warrants done and get them quickly but they weren't getting there. And they couldn't figure out, why is this, oh, for Pete's sakes. why is this taking so long? You know, we're doing all this stuff right away. And so in talking to staff, it was discovered that the clerical person that would typically be in charge of taking these documents to a judge for signatures wasn't doing it because there was only one cart to pile all these files on. And somewhere I don't know if she'd gotten the message or someone had expressed irritation that you're going up there too often. Wait till you get the cart filled and then go up there to the judge's office. And I mean, you try to bite the insides of your mouth not to laugh a little bit or get mad, but that is what she understood as a problem, that she was being rude by going up there with just a few files and taking away the cart from someone else that might need to use it. I mean, and we thought, wow, how important it is to bring in our staff people, not just prosecutors and police, to trainings about victim safety and prioritizing certain kinds of cases and documents. So I could go on, but you get the idea. Is don't just think of this as something vague that you can't do anything about, or a lot of times they're very specific, where if you just did a little investigating yourself, you could figure out like, wow, this is a real backlog area in our office. Monitoring and tracking, as you can tell, I've had a lot of experience with what I would call, I think, community participatory research projects, or community level qualitative research. And I really like that because you can't, I think, learn about prosecutorial gaps and difficulties only by the numbers. And quite frankly, I think it's offensive, and I think it's why many prosecutors are reluctant to share monitoring and tracking and sort of data from their office, because domestic violence cases are hard to prosecute. And if you just look at only, gee, you only got X many convictions, then you're going to get slammed by the media. And there often is a lot of really important qualitative explanation to that can much improve the kind of information you're getting and thus the response you might take. So monitoring and tracking is not as easy as it sounds. Yes, all the numbers things, there is software for that. But I put this little cartoon here where you've got the tension between dogma, like people that are just about the numbers. If you can't measure it, you can't say anything about it. And then you've got this other person who is way on the other end of the spectrum saying, well, you can't measure the important stuff. And then the cartoon is, the truth is somewhere in between. So I would encourage you, when you think about monitoring and tracking, what are some ways that you can incorporate good quality qualitative information that goes along with the numbers that you can easily collect? Some people do victim focus groups occasionally. Some people do victim surveys. Some people have case reviews where they actually give people a chance to talk frankly in meetings about case difficulties. One of the communities that I worked with, I think this is a wonderful practice, is to really kind of allow some constructive venting for those times where police get kind of mad at prosecutors for not prosecuting certain cases, is having monthly meetings about cases that were declined or dismissed, and give prosecutors a chance to explain that. And in some instances, it actually gave marching orders to the police, like, we could still make this case work then if we did X, Y, or Z, but you wouldn't have gotten that information without that meeting. Resources.
Rhonda,
Oh, please go ahead.
Can you talk about how to get to that point where you can have the conversations with the prosecutor to find out, okay, if we look at the conviction rate in New Mexico, average of 11%, we want to find out why that is. And one of those reasons that you just pointed out is it could be the law enforcement reports aren't sufficient. Went to the house of a domestic. That's all that was in the report. That's not enough. So how do you get to the point where you can get the prosecutor to have that conversation with law enforcement, where domestic violence advocates, anti-domestic violence advocates, battery and intervention program staff can be a part of that?
I know Ron and I were talking about this a little bit yesterday. So and I said, I think the first important thing is to acknowledge that it's difficult sometimes. As I said, I come from a small town / rural area, and as one supervising law enforcement officer told me privately after a meeting, because he didn't want to say it in front of anybody else, he said, what you've got to remember here when you talk, because we were having a meeting about updating policies and then doing some training, and nobody was objecting to what I was suggesting, but he took me aside afterwards and I think was just trying to give me a warning. He said, people that work in prosecution and law enforcement here have gone to high school together. They've been each other's best men at weddings. They go out drinking together. They play in the same softball team. They've probably recommended each other for jobs. And he said, that kind of police supervisor or that kind of person that's overseeing police reports in a prosecutor's office is not going to go to that person writing the report and chew that person out. They're not going to be comfortable going back and saying, we need this and we need that. And I thought that was a really good example of the difficulty, especially in smaller towns and rural areas, of talking to someone about their data or their documentation. So with that backdrop in mind, that that I understand and empathize, I think taking more of an incremental approach as opposed to thinking, here's the path A to B and it should be like this and I should get what I want. So I'm going to just say two things and I'm going to stop and see if Ron would like to add anything. Is if the situation is that you have not simply had a relationship or had any communication or any attempts to communicate, I would, before getting into data related conversations, which I think can be kind of scary and off-putting and create defensiveness, is build a relationship with that person first about domestic violence generally. Have lunch or coffee a lot of times, not just once, before you ask for something. And just get to know what each other does, kind of what the issues are, and then move into something where you're starting where the door is likely to be open. So if, for example, there are issues with a police report, it may be better to start out with a certain type of case as opposed to approaching it like the whole wide world of DV has gone to hell. And so again, an example might be as well, strangulation cases are exceptionally difficult, and we've just had a new statute or new training on that. Could we look at some of those cases, blah, blah, blah. That's number one. Number two, the more difficult situation, I suspect what you're alluding to, David, is where there's some negative dynamics already. Maybe there has been some past history of difficulty between the two organizations. Maybe the prosecutors had a bad experience with sharing information in the past. But in that situation, what I would do is try to be aware, perhaps through a third party that's friendly to both, what those issues might mean. And I mean that carefully. I don't mean in a gossipy way, but try to figure out maybe what the history is there. And I think proceed with that person and acknowledge that and ask and start out again, not by asking for data, but what you can do to fix that. So an example that I'll give there of working in a project just like this, a coordinated community response, but this was kind of unique in incorporating attention to family court because they use so much information related to domestic violence, but often aren't included in CCR efforts or training. And one of the people on the team became very upset at some of the things that she was learning about judicial decision-making in those cases and the use or lack of use of information that would have helped them and so on and so forth, and became so angry that she just couldn't wait and wrote a really awful letter to the editor that was published about what she was discovering. Of course, nobody wanted to work with that person again. It really kind of tanked the efforts. But what somebody wisely did was just kind of gave it some breathing room for a few months, somebody on the team, and went to talk to that person and said, and she had quit her job and she was so upset. So they said, you could really help us fix this. It's going to take a while if you apologized and acknowledged what we were trying to do. And so she did. It took a few months, but she wrote a very thoughtful letter to the editor, and they published it about what she had done. And she realized the damage that she had done to the relationships between law enforcement, prosecution, legal services, advocacy, and the judiciary. And was hoping that they would try again to communicate with one another, and that she hoped that her apology and the recognition that this was not a team action, but just hers, would move them forward to the sharing of information and the ability, to evaluate themselves and so on. So that's my two things. I'll stop there and see if Ron has anything to add.
Well, I think I could just deal with the experience that I had here in Taos. For me, this is back in the 2013 to 2015 timeframe, but when we would attend our coordinated community response team, we would encourage and began encouraging prosecutors, our line domestic violence prosecutors, to attend those meetings without fail. And it became a requirement within the office that they do so, because that hadn't always been supported. There wasn't always a district attorney that wanted that kind of communication. And we've been very lucky here in Taos. I think we've had a very good district attorney for a number of years, and now we have a new district attorney, but they're very open here to working with our coordinated community response team and with our community agencies that are supporting them. I think that by having the line prosecutors at the meetings, they were able to see quickly the benefits to be gained, how quickly they were able to develop a relationship, if not directly with the victim in a certain case, then they were able to find out from the treatment providers what status or where the victim was in her treatment. They were able to find out details about the children and where they were attending school, what issues they were having, had they a need for counseling as a result of that therapy. And by getting the line prosecutors there, I think that it really got that information to flow up to the power that that meant it, which was the elected district attorney. And you have some people that have been in prosecution for a number of years. They have developed their own opinion, and some may be right. And so we have some amazing prosecution, and we also have some people that have, they're human beings, and they may have been jaded at some point or had their own experience with domestic violence, or the feeling of helplessness that's kind of jaded them against having a willingness to help. And so they've kind of shut down and said, we're not going to be part of these community ventures. We're going to do our own thing, and that's to prosecute cases and prosecute them hard. I'll tell you, though, that the developing a relationship that Rhonda mentioned and being open to trying to come at this from a different angle, probably I don't know if it's unique to prosecution, but when somebody's asking at the start of a conversation for the metrics by which you gauge your success, it's probably going to put you on the defensive. And so if you're able to build relationships outside of just knowing, if you're able to build a relationship beyond just the prosecution and the business relationship, then that's great. And to kind of let them know what you're about, that you're out here to help them, that you want to support their job in this community, and to do that by providing them the support that they need and helping their line prosecutors. We would send our line prosecutors, and we've talked about some reports being poorly written, but we were dealing with on occasion, and this is not a criticism, it's just a statement of where things were years ago, because they're not there anymore, but we were having a hard time even getting victim information or survivor information, their actual address and phone number listed into a police report. And so once the case got to the prosecutor's office, we weren't even able to reach out to that victim. We'd have to make 3 phone calls to try and figure out where the victim was. And that was a real problem with some of the police reports that we were seeing. And so by getting our coordinated community response team together, by having an officer who was at all of the meetings, who could then kind of see what the community was talking about and the difficulties with interpreting some of these reports, then that police officer or that prosecutor was able to take that back to their supervisor and say, look, they've got a point here. We had a gap in the system, and look at what we need to do. We really need to train our officers better on this point. And you're able to get either with that line prosecutor or that officer that you've got a relationship with, if you can get them to come to your coordinated community response team, then you're going to have somebody that's already in that office that can take that information to the powers that be. I do know that there are prosecution offices, as I've said, that kind of build a wall. And the way around those walls sometimes might be to go out to your legislator or see who they're friends with. They got elected in some form or fashion. There are people out there supporting them who think they can do a good job. Well, you have to go find those individuals and build some relationships with them too. If there's a legislator that you know your district attorney is friends with, well, maybe as Rhonda mentioned, that kind of third-party friendship would be the way to get into that office and kind of break down those walls. And so I guess that would be my comment on that. And how you get to that point is it's not easy. It takes time. You may have to try some different angles, but I think you can get into that office either by having someone from that office join you at your meetings, or by kind of working from the top down and making alliances with some of your elected DA's friends too, and having them share with them the important work that your coordinated team is doing.
Yeah, I think also it's be able, if you can, to offer something in return. So, and again, I don't want it to sound like you'd be so crass as to sort of blackmail the person, or if you do this, I'll give you this. But in part of that relationship building, maybe you can offer, maybe you've got a really expert person on your staff as it relates to some aspect of domestic violence. You could offer training or shift roll call sorts of little education events. You could, if you're planning to write a grant that includes them and gives them something like a position or, financial resources for something else. But those are other things I would consider is what's in it for them, to be blunt. Is there something that you can offer them that they then benefit from their relationship with you? David, were you going to say something? I think I may have interrupted you.
No, I wanted to say thank you. What you're both talking about really bears out in my experience, in my community. In the beginning, the police and the survivor service organization would not be in the same room or the same building together. And literally, and this is documented, I'm not telling people's private business. The police were convinced that everyone who worked at the shelter hated men, were all lesbian, and wanted to convince women to become lesbians and leave their relationships. And the folks at the shelter just thought the police were a paramilitary organization, who liked their guns. And really, it took a lot of work on a lot of external advocates' parts outside of those two systems to bring everybody together. But they were able to overcome that in a powerful way that led all the way to the judicial oversight demonstration grant, and really strong relationships recognized all the way to the White House.
I remember those days. That was another good example, David. Thank you. Another thing here is, and I bet everyone's had experience with this, is what it is that we mean by the prosecutor supporting community resources. And you can see a list here. I don't think I need to read them out loud, but I wanted to display this picture of mixed messages that I think often occurs. And we tell people to leave, for example, you should leave this relationship, it's not safe, but you're in a community where there's no place to go. There's no shelter, or the shelter is full. Or they are able to find shelter for like 2 nights, but then they need more long-term housing until they can find, and there's no long-term housing available. Get a divorce, and there's no legal services in the area. This is one thing I heard when I did focus groups in rural Nevada a few years ago, is they keep getting told that, but the closest legal aid attorney is like 5 hours away. I mean, and they're already overscheduled as it is. So I think a lot of times we say these kind of blithe statements. There's help everywhere nowadays, come on. And yet we haven't really made ourselves very knowledgeable about the resources that exist in our community, the limitations of them, and supporting people at those community-based programs in building additional resources. So you might, even something as simple as being available to write a letter of support if somebody's trying to write a grant for additional housing, for example, additional programming of some sort. If an additional position to assist people with protection orders is necessary. All of these things are things that it's not enough for you just to say, kind of be vaguely aware, yeah, I think something like that's out there, but be aware of specifically what it is, what it does and doesn't do. To be, again, blunt, there are some programs that are not of very good quality. That also is important to be aware of. I can remember a place that I did a site visit had a number of choices that you could have in Batter's programming. One was like a weekend, an intense weekend. Another one was a few weeks long, and you get the idea. And I found it fascinating. These people were actually in the hallways and the courtrooms with brochures, kind of like those guys at the airport that are trying to sell you something. And and the judge said, well, it's kind of a free market thing. I don't feel it's appropriate for us to direct somebody to a particular program. And I was stunned by the fact that they would permit someone to sort of take, quote, a weekend program over something that took longer because, you know, who wouldn't? But they knew nothing about the quality of each of those programs is what I'm saying. And so when we talk about resources here, we're talking about those for survivors, but I think this mixed message situation applies to programs for offenders as well. Here's where I was going to tell David to jump in. As David said, I've known him for a long time and I had to give him some street cred here. So if you're going to intervene with abusers, this poster that was created by the organization that David used to work for was the first time that I'd ever seen anyone collect information from batterers as to why they do what they do. You've all seen the power and control wheel. And for those of you that don't know this, that wasn't just some theory that some advocate slapped up on the wall and drew a picture of, or some psychologist that wrote a book about. That was created from things that victims actually said. So in the 1980s, doing support groups with over 200 women over the course of about a year or two, that's how that power and control wheel was created, which is why I've always thought so much of it. It's what people actually said they experienced. And that's why I like that. I've never seen anything else like this as it relates to abusers and programming. David, I don't know if you remember this, but you actually gave me the Word document that's about 8 pages long. It's a list of things that men in these groups actually said. And that's what all those tiny little sentences are behind the no excuses, is what they actually said. So I have those too, and I can send them to people, but that's where I first began thinking of someone running a men's program actually being an expert on behavior and mechanisms of abuse, in the same way that we might think of an advocate as being an expert, or a victim being her own expert on what's happening. And so I think it's really important to think about that when you're thinking about gaps in intervening with abusers. Is all the excuses I saw in there are things that I've heard police officers say, prosecutors say, judges say, like he was drunk. He was just drunk. When I was prosecuting, one of the judges I practiced before, who had been a prosecutor for many years prior to that, and a very well-respected one, was a recovering alcoholic who had really achieved a great deal of personal success in life through the 12-step program. And to him, that was the answer to everything. So the answer to every crime was, if you took the alcohol away, if you had the probation officer go in there and check the refrigerator once in a while, if the people in the courtroom that were the defendant's family members, you kind of had to give them a message and kind of, figuratively speaking, knock their heads together about, you guys shouldn't be bringing beer in the hot. I mean, all that stuff was stated, but boy, battering programming, no contact orders, risk assessment, that was never mentioned because that wasn't perceived as the problem. And so that is a gap I would throw out there, is thinking carefully about the kinds of excuses that you hear from the men in these programs, the abusers, are things that are often reflected in our own society, which then that's where the people that work in our systems come from, is our world where these kinds of things are stated. So I think thinking carefully about not just intervening, but how it is that you're doing it, the kinds of messages that you're giving, and what it is that you're learning about from abusers themselves that will better aid and better tailor your interventions in the future. David, would you like to talk more about this poster that I got from you?
Well, I can just say that I actually still have these, we back in those days we sold them for $5 a piece. I can talk with the coalition about making these available beyond that. But what we did was we listened to the men in groups for about 6 months and then wrote down, every time we heard an excuse, wrote down the excuse. The list that you have, I think, is the one we actually took the time to alphabetize.
Yeah.
And put it in that order, which then we worked with the graphic designer. And once we had that concept of no excuses, in order to say no excuses, you have to know what the excuses are and why they're excuses. So it really does get to the heart of that matter, like you were saying, of listening to the experts on perpetration, and those are the men in our BIPs. We have a question from one of our faculty coming up the road here, and a friend of yours also.
Hey, Jim.
Jim, you can
Hey,
go
how
ahead.
you doing? I was going to say you could also talk about the bus, because you remember for a period of time they'd say red bus because it used to be wrapped. You took all of that, and that was a really good campaign.
What Jim's talking about is one of the campaigns that we did in the community that Jim and I used to work in, was a city bus that said no excuses on the side of it.
Oh, that's cool. I didn't
had a few of these excuses written on it. It was a way to educate the community. And then the big red bus took on a life of its own, because it actually became a saying for a while, that you would use in a sentence when somebody would say something, and rather than saying when I was a teenager, we'd say duh, people would say big red bus, as if it should be that obvious. So that was kind of fun.
That's really, I did not know that story. That's really cool. Thanks, Jim. And I mentioned the power control wheel, and I'm sure people are kind of going, oh gosh, I have to look at this again. But there are many stories I could tell about this wheel. Today, it just seemed like a good fit to mention it here as it relates to undoing the harm to children. So what we mean by that is a CCR could play a really important role in protecting kids. If you really thought through the sort of a consistent, helpful approach to visitation and custody, because sometimes that will be impacted by bail conditions or probation conditions. If you have a no contact or stay away order from the home, sometimes what a family court might expect or be involved in, you're setting the family up for the kind of conflicting orders or conflicting understandings is what I'm trying to get at. Other communities have gone the route of a child visitation center, which sometimes is just presents kind of a safe space. But other situations, people have used it as a way to gather information and be a part of the team to help reform the court or aid the court in becoming better at these decisions. And so I think where this becomes important for a prosecutor, when you think of what might create impediments or fears around testifying in court, for example, is how children get used in domestic violence cases. So I can remember doing focus groups where at a sexual assault advocacy program where a number of women reported being forced into sexual relationships with their ex-partner in order to be allowed to visit kids, or in order for him not to sort of obstruct that process. That's something that had never occurred to me prior to having a focus group like that. Other women have talked about threats to kill the kids, kidnap the kids, or financial things like I'm not going to be available to pay child support or to help you parent the kids. So these are all things that often arise in the context of a criminal prosecution that I think is important to be aware of and can really hamstring us if we are conscious of undoing harm to children, and yet you've got a family relationship, and yet these kinds of dynamics, these negative dynamics are happening with the kids. How is it that you undo the harm? It's not an easy answer, but it's important to be aware of.
One of the things we really focus on up here, or try to, I think they probably do it around the state too, but the children have become a focus, certainly of our family court up here, and seeking orders of protection. One of the things that is very difficult is dealing with, people don't understand necessarily that because they've been abused, that they may not be able to have full custody of their children. The two don't necessarily go in hand. So you're going to have to try and work with your survivor and let them know that we're going to try and protect your children the best way that we can by having treatment available to them if they want treatment, or if they're not necessarily the children, but if the parent feels that children need treatment, they'll have an assessment done of the children, oftentimes through one of our agencies here in town, to see what harm or trauma they have experienced within the home, and then hopefully engage them in services. But it's a very touchy situation when trying to explain to a survivor that being abused doesn't necessarily in New Mexico equate, or really around the country, to having custody or sole custody of your kids. It's how can we best keep them safe, and as you said in an earlier slide, reorder, I guess it's right here, as their primary relationships are reordered. It's going to be difficult, and it's not an easy issue to deal with, but our courts are beginning to focus on and realize the impact and how some quick intervention in making sure these children are supported can be so important to stalling, hopefully, the situation that they're in, and then actually bringing them back to learn that the way that things are at home haven't been going correctly, and this is how they're going to change.
Yeah. And last, then we'll move on into more specific aspects of prosecution, is this concept of evaluating our responses. And I think we got into that a little bit through our monitoring and tracking discussion, so I won't spend too much time on this particular slide, but it's important to remember that what we're evaluating is the experience of the victim and the carrying out of our mission of victim safety as opposed to our own efficiency. So as the only person in my office prosecuting domestic violence, I certainly felt a lot of pressure to respond to all my phone messages, emails, and get my complaints done and motions filed. And And those often felt like a measure of success to me to kind of check off the to-do list, you might say. But in my early days, I didn't really think as much about how it might be perceived successful from this woman's standpoint, whether she was being treated respectfully, whether she had an opportunity to communicate meaningfully, whether she was being made safer by involving herself in a prosecution. And so I would just caution you, if you choose to evaluate yourself in some way, whether it's some informal project locally, or maybe you're going to engage a local university member into participating in more classic research with you, is that you make the focus or the goal of your research or evaluation about the victim's safety and her experience, and not your own, your own efficiency. And so once again, I'm going to welcome you to provide, I think, some success stories or things that you think that you're doing well, maybe an innovative or best practice that you're exploring as I move forward into particular aspects of prosecution. So we've talked about the work of a CCR, how that might connect particularly with the work of DB prosecution, those 8 activities of a CCR. And now we're just going to march through the actual process of prosecution and talk about how that can be more effective with your partnerships, again, as opposed to trying to be the Lone Ranger and doing this alone. So in charging, and I'm going to do that basically by just giving a quick example of each of these. Your domestic violence prosecution can be more effective within a CCR and partnering with your CCR partners through better partnerships with your police officers, investigators, and a common goal of being willing to evaluate yourself. And so this example that I have from my witness intimidation project that I mentioned is just the fact that we had a meeting there with all the team members, including police supervisors and investigators, about what we'd like to do. In other words, study witness intimidation in their city. We did a little miniature training for them so they understood what we meant by witness intimidation in domestic violence cases and how common it is. Just that supervisor going back and sort of very excitedly and passionately sharing this with his staff really kind of pumped up people to simply document witness intimidation in the report. So he very excitedly emailed me afterwards, about a few weeks after this meeting, saying, gosh, Rod, I was reviewing reports and I came across this really great report that documented witness intimidation. And so I wanted to point this out to you, that when we evaluate, we're not only looking for bad things, we're also looking for good things that we would like to promote that people do. And so by doing evaluation, you're not just going to uncover problems that need to be addressed, you're also going to uncover good practices that you could actually display during training to police or other staff that you would like to promote and encourage be continued. And so here is a good example of that. Short version of the story is this woman had experienced a domestic violence incident with her estranged partner, called police. He'd been charged, he was being prosecuted. There was going to be a court appearance the next day. Well, guess who kicks in the door because he's mad because there's a court appearance the next day. And so she called the police. And so this is the kinds of things, it's a very thorough report. And so I just pulled out some things that a prosecutor would want to show that this person is intimidated, that she is scared about testifying. And so I thought a really good thing that this person did is gave concrete information about evidence of her fear. In other words, he didn't just say she was scared or she said she was scared to go to court tomorrow. Sobbing and breathing, hyperventilating. It was difficult for her to talk because she was breathing so fast. Difficult for her to calm down. She cried the entire time I was there, kept walking and pacing around, had a hard time talking, said she was scared, she was shaking. So he's describing not only her physical demeanor, but he's doing that in addition to what she is saying. I just thought that was fantastic. And I thought this is, a prosecutor would need this to show that this person was genuinely intimidated from coming to court the next day. Then he also asks and gets direct quotes of what she remembers that he said that would have to do with the court appearance the next day. I got my eyes on you. You're going to put me away. You're going to testify against me. The cops are looking. These are direct quotes in the report. This is what she remembered that he said to her after he kicked in the door. And so then the officer, he's got evidence of her fear. He's got evidence of this guy's intent to intimidate her from testifying. And then also basically as recommending to the is signaling the prosecutor what he's thinking the charges should be. So I thought, wow, this is fantastic. And I thought, what a good thing for the supervisor to have done to sort of share this really great project coming up, kind of inspire the troops, so to speak. And then not only that, but then take this guy's and show it as a really good example of what we want you to do. That prosecutors really need this. So this is what I mean by partnerships. You can't just expect people to know this without talking to them. And you can't expect to address domestic violence really effectively as a prosecutor without having these kinds of partnerships. That was for charging. This next, we're thinking about bail and bond. I mean, we're not going to trial every day, but we are often charging cases and we are often appearing at bail and bond hearings. And so prosecutors are in a distinct position along with law enforcement officers, investigators, and victim advocates to articulate threat and safety needs that should be articulated during bail and bond hearings where conditions might be set to address those kinds of fears and safety issues. And they also then have a role in establishing and kind of reinforcing this interagency work in bail and bond. Again, it's not just the prosecutor that's going to do an effective job by him or herself. So I am going to just, and again, you'll get the PowerPoint. It's these next few slides are kind of blabby, but I just wanted to show you that it isn't me paraphrasing this. This is what actually happened in a court appearance. I set up Google alerts for myself, so I get like really neat stuff on witness intimidation, stalking, risk assessment. And I found this, it's unusual to have a bail order appear in legal research software programs like Lexis for Westlaw, for example. But this popped up and I just thought, wow, this is fantastic. I've got to use this at a training. It's not a final case decision. It's a bail order where the prosecutor, investigators, and victim advocates went to quite some trouble to prepare this case of why they didn't think that this person should be let out on bond. In other words, held without bond. In some states, we would call that a dangerousness hearing. In other words, you have to have a hearing to show the judge why this person is so dangerous that bond should not be issued. This is a person that was a campaign aide in some local campaign in Michigan, I believe, if I remember correctly, David, so that might be of interest to you. And long story short, he had sort of developed some resentment of a number of girls in high school that had rejected him. And so he had gone to a lot of trouble with the kind of information access that you get through campaigning, through census things, getting people's email addresses and phones, of connecting with these young women, kind of under the auspices, kind of like you would on Facebook. You occasionally get these messages from old high school classmates. Hey, do you want to be a friend? And then somehow figuring out so these women were not handing over personal information to him. He was able to figure out passwords through kind of some social engineering stuff, where he then was able to see like folders that you might keep in your email account of personal pictures and so on. So what he was doing is starting to blackmail people from anonymous numbers with these personal photos that he had gotten, and then asking them to send more photos, or, and some women did for a while because they were so scared of these getting out. So this is the case, and I've given you the background. And so this went on for a year or two where we started blackmailing. It became very cruel, you know, threatening their lives and their family members. And so finally, one of the victims came forward, and there was quite an extensive investigation of what he had done. I mean, he had 25 computers at home, a lot of cloud storage. It was quite extensive. And so what the government was saying as far as the fact that he was considered dangerous is he wasn't turning over all the stuff that he had. So there was a lot of fear amongst victims that he'd already gone this far in blackmailing us, threatening our lives and our families, ruining our jobs and careers and so on, and our reputations. And we don't know what he has access to if he gets out. You know, what further harm can he do to our lives? And so this, I thought, was fascinating, because you typically would not get a conceptualization by a judge that this kind of computer stuff would be dangerous. But given the teamwork of what the victims were able to uncover, advocates were able to uncover from lengthy conversation with victims about their fear level, and what the investigators were unable to uncover about all these devices and what was stored there, the judge felt that there was a legitimate determination on his part as to whether this was a, quote, threatening or intimidation of witnesses. And so they looked at his capacity to do that. And so they looked at what the investigators had documented about his cloud storage, how he had documented the names and other information about victims, kind of like a plan to extort from victims, and the hardware that they had collected, all the electronic files that they were able to uncover, which wasn't all of them, as I said, and his obvious kind of very expertise and astuteness with just technology in general. And then they looked also at, well, his willingness to do that in the future. That would help them predict whether how dangerous he was. And so they then stepped through again through the information from advocates, investigators, all the stuff he had done so far. In other words, he had carried out his threats, carried out many things and done so successfully. And also that he had carried some resentment against some of these women for like 5-6 years. So he'd obviously been thinking about doing this for many years. And so here's what the judge said is, even though he had tons of people show up on his behalf and talk about their willingness to monitor him and what a good person he was, again, very unusual, but lots of people came up to support this person. But the judge said that he had weaponized. And I just thought, what a good job the investigators and advocates must have done in articulating this, because I've never heard that before. In effect, he has weaponized items like electronic files, information with which he can blackmail and extort people. And I just thought, I still get goosebumps thinking about the work that these three entities did, prosecution, advocates, and to convince a judge to do this. And the judge even says at the end, I note that this was a close call, which could have easily resulted in another outcome. But even though he had a lot of family support, I cannot overcome the determination I've made of serious risk of danger to victims. If that isn't an example of like the importance of that teamwork at the bail setting stage, I don't know what is. Because it's obvious the judge wouldn't have made that decision but for that level of information.
Rhonda, I know we've got 10 minutes left, and there's one question in the chat and another question that I'd like to get out there.
Okay, go ahead.
Okay, so in the chat, I don't know if you've got that up, but Tiffany Korn asked if you can suggest a beneficial trauma training for employees working with survivors to make a recommendation to our district court employees working directly with the community.
Yes. Can you, are you able to sort of compile any questions like that you get in a chat and send it to me? Because I do have 2 or 3, they're regularly conducted kind of trauma-informed trainings for criminal justice and court staff. And so I can put the person onto that.
Okay.
I'll need to be reminded, though, is what I'm saying. So thank you.
Okay, I got that. And then the other question, this is a little more remedial, but can you briefly talk about the relationship, the intended relationship between the prosecutor and either the sheriff or the chief of police? You know, the prosecutor is the head of law enforcement. Is that correct?
I think some would disagree in some jurisdictions, but like where I worked, yes, they would say that was kind of like the chief law enforcement officer. I think that's often stated about our U.S. Attorney General, that is the chief law enforcement officer. I mean, other places, I think a sheriff would perhaps take umbrage to that, but generally speaking, that is what is stated in most jurisdictions.
Okay. Ron, you were going to add?
Yeah, just New Mexico actually has a statute stating that the prosecutor, the district attorney of each district, is the chief law enforcement officer of that district. So they actually set out by statute, I think, to hopefully resolve any conflicts that may arise between the two or more entities in each district.
Yes. And another reason why the legislative person is here, that's a great, I wonder if that's perhaps true in other places as well. I'll have to, you're making me think of something else to put on my to-do list. Thank you. Trial, as I said, we often concentrate a lot on that in prosecution trainings, and yet we're not trying every case. Each of these things, these bullet items here you see are things that I've actually done a separate training on. So obviously we can't get heavily into each one. But again, to the extent that you think of these being necessary and important places of partnership with other people in the system, witness intimidation, you're not going to know about it unless the advocate tells you or the victim tells you. And so research tells us that victim intimidation is common mostly in gang cases and domestic violence cases. Prosecutors who've been interviewed about this across the country says it happens almost all the time. And so it's particularly going to happen right after an arrest or right before a court appearance. And so it's really important to be alert to it, both in pretrial communications that you and your advocate or law enforcement person is having with victims before a trial or a hearing, but also in the courthouse itself. The project that I did, it's pretty jaw-dropping, the amount and the styles and mechanisms of intimidation that you would see, some of it very subtle in the courthouse or in the court hallways or the court parking lots, you name it. And Duluth, one of the cities, actually created a policy for their court security officers based on this project. They had never had a policy before, and I'm not aware of any other court security staff in the country that has a policy for them to respond on witness intimidation in the courthouse. Court environment issues. I just did a presentation recently on gender bias in the criminal justice response to domestic violence cases. And I was really surprised at kind of the icky behavior that we let people get away with. I'm not talking about witness intimidation by the abuser to victims, but I can think of a really crowded courthouse I was in not long ago where it was just packed and you had just stupid young men stuff crawling around on the floor, sniffing up women's skirts, and court security officers kind of going, well, what can you do? It's just guys being, that kind of thing. And so I'm thinking just sometimes we're so jaded to some of this behavior that that would be kind of off-putting to a person not used to coming to court, that we're not aware of how even something just like behavioral issues, people being rude to you, people being short to you as they're doing the wand of your purse. There are a lot of those things that are consistent issues in some courthouses in the country that victims often say, I just never wanted to come back there. And so I think we're often not aware of things like that, often I would see the physical plant or behavioral issues that aren't addressed in court that are really off-putting for victims. Pretrial motions, I can think of cases where the victim said he's going to blurt out that I had an abortion 10 years ago, or I can think of a case where he claimed he was going to claim in an untrue, and it was not true, but that they were having an affair. I can think of another case that a colleague of mine worked on where the victim was older than her ex-partner. And so there was going to be a lot of snide, gossipy comments, that kind of had the impact of embarrassing her because she was older. And so these are things that you can be alerted to, again, by good communication with your advocate or investigator, that are going to come up, that you can help protect the victim's willingness to participate in the prosecution, as opposed to just doing nothing and just thinking, well, it's not evidence related, so and making that person feel embarrassed or reluctant or unsafe to participate in a prosecution. Witness preparation, that goes without saying. Expert witness consultation is something that I mentioned earlier, that we think of that as explaining victim behavior and utilizing an advocate to do so, which is of course a good idea. But it may also be, depending on who your audience is, whether a particular judge or a problematic jury, you may want to consider using someone like David, who has worked with men. You're going to be hearing from Scott Miller in a few weeks, and I would welcome you to ask him questions about that, because that's something he and I have talked about, and he's actually started doing expert witness testimony as someone that can speak to both behavior of the men that he works with, and then also of the victims that he had contact with, and he's been very successful. I've been consulting the last 4 years on older women victims of violence, and have found really interesting issues related to accommodations that I would not have thought of, that other people obviously aren't either. But I would suggest thinking of that as well, that you have someone that's much older that may have difficulty with medication, or walking upstairs, or cognitive issues that aren't maybe readily visibly apparent, that these are things that that you need to be aware of too, only through your communication with advocates and investigators often. And to the extent that you can, to learn from judges or juries. You can't invade the province of the jury or inquire into their deliberations, but in my court, judges would let investigators who wished to learn from jury verdicts speak to the jury if the jury welcomed it. And so I usually asked if they wanted to, and most of the time jury said, yeah, we don't want to talk to you, Rhonda, but we'll talk to the police. And I was often stunned at what I learned, that wouldn't convict a guy of child abuse because they didn't believe kids were capable of being witnesses. I was stunned at that. A woman that lived with the guy before breaking up with him, or I had a lot of older ladies on the jury that felt that it was a crime to live outside of marriage. And so she committed a crime by living with him. And so the two canceled each other out, him hitting her. And so they decided to acquit him based on a lot of things that I wouldn't have thought of. And so I think it's important to help your partners who are struggling with these cases learn, instead of just feeling bad after an acquittal and thinking you did something wrong. I found out most of the time that wasn't the case. It was because of stereotypes or other things that I wasn't aware of. Sentencing is, take this slide and repeat it. But also, I think being aware of offender programming, as I've said before, all are not equally good. So be aware of them and learn about them before you make recommendations to utilize them. Risk assessment to support conditions about no contact orders and so on, instead of just assuming. Sharing information with probation. Sometimes there's difficulty with the way that we share files. That is obviously not conducive to good probation planning if there's no communication with the prosecutor. here's something that I would suggest that you consider that I think most people don't, is the place that there is for communication and advocacy after the case is over. I did a project of looking at dismissed cases and the real harm that some victims felt that nobody talked to them about these cases. One victim in particular just was stunned that it was dismissed and asked to see the file, and of course saw things like snotty notes, comments by police officers that she wasn't aware of. And I thought, gee, she should have had an advocate working with her in that situation. And David, I know we're at the end of our time. So the last few slides that I have here are about transitioning our thinking about risk and safety as prosecutors now that we have this information about CCR and this information about how partnerships then make our DV prosecution more effective. So things to think about here, I think are well done just by displaying this graphic of risk and safety is not only impacted by batterers, but also by our individual life circumstances. For example, are we disabled? Are we, do we have a cognitive issue of some sort? Are we undocumented? And then also risk and safety impacted by our systems themselves, and sometimes the inadvertent things that we do, unfortunately, that put people in more harm's way. And so when you think about using risk, think about those life circumstances and systemic circumstances as well. A wonderful resource for using risk assessment is the Battered Women's Justice Project's Integrating Risk Assessment and a Coordinated Community Response. They have a whole page on it, and free checklists that you can download for each part of your system. That's something I will save for another time. And then accountability and how it shapes our philosophy, which is what Ron pointed out was our first message, building a common philosophy, is just remembering that offenders are not the only persons that we're trying to hold accountable. This CCR is also to hold ourselves accountable to victims, to one another, and agency to agency. And so when you get this PowerPoint, I actually interviewed a prosecutor about these 5 different ways of accountability. Now, again, not only about the abuser, but practitioner to practitioner and agency to agency. And so you'll see here how he answered each of these questions during the interview. And I hope it gives you some ideas of how you might answer these questions when you think about accountability as this 5-tiered question and not just our attempt to hold batterers accountable. I've got a little problem-solving graph for you, and that's it. And my last comment to you is to remember a bad system will beat a good person every time. This doctor that you see quoted is someone that is considered like the father of quality control in the corporate world. And that was one of his favorite quotes is, if you don't improve your system, you're going to beat the good people that are working in it.
Rhonda and Ron, I want to thank you both from the coalition and from everyone who was on this call for everything that you gave us. Everyone on the call, you will be receiving an email from Terry with all the resources once we pull all of that together, including the PowerPoint, answers to the questions that were asked that we didn't get a chance to. Time went by so fast.
I know it.
Both of you.
Crazy.
Thank you. Thank you. I'm going to turn it back over to you, Terry, and you can close this out.
Thank you. And I definitely agree with that. Time went super fast. Even though it's a 2-hour training, it did go by super, super fast. And so I'm going to put in, as mentioned earlier, the survey for your certificate for those that are still on here. So please fill out this survey, give us your feedback, and you'll attain your certificate for this session. I'm also going to put our MailChimp listserv in the chat. If you are interested in receiving our future training information that maybe you would like to share with your network, we are going to be putting the information out for the next training or session number 4. So please keep an eye out on that. And you can also follow us on Facebook and Instagram. So thank you all so much again for spending time with us. And we hope to see you in a couple of weeks for our next upcoming training. And I hope you all have a fantastic day. Let us know how we can.
Thank you. Thank you, everyone.
Thanks, David. Thank you, Rhonda and Ron.
Thank you, Terry. Bye-bye.